The Department of Justice has just changed the rules, and hundreds of thousands of immigrants across America may not even know their protection is gone. If you have DACA status, an open immigration case, or a pending appeal, what you hear in the next few minutes could be the most important thing you hear all year. Welcome back to Immigration Updates today. Today, we are covering one of the most serious immigration developments of 2026. In the past few weeks, the Department of Justice and its immigration court system have issued decisions that are completely reshaping how deportation cases work in the United States. We are talking about a ruling that directly affects DACA recipients, immigrants in removal proceedings, and people who depend on the immigration appeals process to protect themselves from being deported. This is not just one small change. There have been several connected moves from the Department of Justice since the start of 2025, and together they are building a system where deportations happen faster, appeals are harder to file, and protections that immigrants have relied on for years are no longer guaranteed. Let us go through this step by step so you fully understand what is happening, who is affected, and what you should do right now. The BIA ruling on DACA, what just happened? Let us start with the most recent and most alarming development. On April 24, 2026, the Board of Immigration Appeals issued a precedent decision that could significantly impact DACA recipients facing removal proceedings. The ruling makes clear that having DACA status alone is no longer enough to terminate deportation proceedings. Let that sink in for a moment. For years, DACA has been the one thing protecting hundreds of thousands of young immigrants from deportation. Now, simply having that status does not automatically stop your case from moving forward. The Board of Immigration Appeals ordered immigration judges to weigh all the factors in a deportation case, going beyond the mere fact that a person has been granted deferred action for childhood arrival status. This decision came from the case of a 28-year-old DACA recipient named Catalina Xochitl Santiago. She was detained by Customs and Border Protection officers while boarding a domestic flight out of El Paso, Texas. She was held in an immigration detention center until October, when a federal judge ordered her release. However, since her release, she has been fighting the threat of deportation. When her removal case was brought before the Board of Immigration Appeals by the Department of Homeland Security, the three-judge panel sided with the government and sent the case back to immigration court to be reviewed. This is now a nationwide legal precedent. That means immigration judges across the entire country must follow this decision. Who does this affect? This ruling sets a precedent, potentially putting hundreds of thousands of people at risk. The same DACA program that has given deportation relief and work permits to immigrants who came to the United States as children. And the targeting of DACA holders has intensified this year, with nearly 300 DACA recipients arrested and more than 170 deported, often for misdemeanors. Now, here is something important before you panic. DACA protections are still in place. This ruling does not mean every DACA recipient will be deported tomorrow. What it means is that DACA status alone will no longer automatically end removal proceedings. Judges must now consider other factors, including the government's reasons for pursuing deportation. What the DOJ has been doing to the immigration court system. This DACA ruling did not come out of nowhere. It is part of a much broader pattern of changes the Department of Justice has made to the immigration court system over the past year and a half. Since January 2025, the Department of Justice has taken significant steps to weaken the immigration court system. It has fired more than 100 immigration judges, reduced the Board of Immigration Appeals from 28 members to 15, and dismissed 9 board members appointed by the previous administration. The Board of Immigration Appeals has issued more than 70 new precedential decisions, and the vast majority of these have resulted in a negative outcome for the person facing removal. Think about what that means. The body that is supposed to review and correct errors in immigration cases is now much smaller, and it is consistently issuing decisions that go against immigrants. In 2026 alone, tracking of board decisions shows the government winning in 20 out of 21 published decisions. This is not a balanced system right now. And the next change makes it even harder to fight back. The 10-day appeal rule, a massive change you must know. Here is another change that has gone largely unnoticed, but could affect anyone currently in the immigration system. A new rule cuts the time a person has to file an immigration appeal from 30 days down to just 10 days. 10 days. That is barely enough time to understand what happened in your case, let alone find legal help, prepare your documents, and file everything correctly. Under this rule, the default outcome for most appeals would now be summary dismissal unless a majority of permanent board members vote to accept the case for a full review. Critics say the rule effectively removes due process protections from the immigration system. According to the American Immigration Lawyers Association, most immigration court decisions would no longer receive meaningful review and would instead be quickly dismissed. There is some important news here, though. A United States District Court issued an order blocking significant pieces of this policy. Several organizations, including the Amica Center for Immigrant Rights and the National Immigrant Justice Center, filed a federal lawsuit arguing that the rule violates the Administrative Procedure Act, the Immigration and Nationality Act, and the Fifth Amendment, which protects people from losing their freedom without due process of law. So while courts have partially blocked this rule, the legal battle is still ongoing. Nothing is final. The situation can change again at any time. Third country deportations, a risk most people do not know about. There is one more piece of this situation that you absolutely need to understand. The Department of Justice has been pursuing what are called third country deportations. This means immigrants can be removed to countries they have never even lived in, not just their home country. A federal judge temporarily blocked these removals, but the Department of Justice appealed, warning that the court order could affect potentially thousands of removals and threaten sensitive diplomatic negotiations with other countries. Board of Immigration Appeals. Decisions have also paved the way for the government to more easily deport people to these third countries. This means that if you have a final removal order, you may not even be sent to your original home country. You could be sent somewhere you have never been before, with no warning and very little time to prepare. Who is most at risk right now? Let us be very clear about who needs to pay the most attention to these changes. First, DACA recipients. If you are a dreamer and you end up in removal proceedings for any reason, your DACA status will no longer automatically protect you. You need to speak with an immigration attorney as soon as possible. Second, anyone currently in immigration court or with an open removal case. The appeal window has been shortened, and the Board of Immigration Appeals is now much less likely to fully review your case. Every single day matters now. Third, immigrants with prior arrests or convictions, even for minor offenses. Minor criminal history is now being used as justification for starting removal proceedings, even among people who were previously protected. Fourth, those who have received final orders of removal in the past. You could be picked up at any time, including at airports and other travel points. And fifth, people who do not have legal representation. Those who are children, detained without a lawyer, have disabilities, or speak rare languages will be most harmed by these new rules. What you should do right now? Here is your action plan. Please follow this carefully. Number 1, if you have DACA, do not wait. Contact an immigration attorney to review your case and discuss whether you qualify for any other form of relief, such as a family-based green card petition, asylum, or another pathway to more permanent and stable legal status. Number 2, if you have an open immigration case or removal proceedings, act immediately. Know your deadlines. With appeal windows potentially shrinking, you cannot afford to lose track of time. Number 3, if you are a DACA recipient who ends up in removal proceedings, do not give up. DACA still carries weight in court when you fight back with proper legal help. We have seen DACA recipients successfully fight deportation when they had the right support. Number 4, keep all of your immigration documents organized and accessible. Work permits, DACA approval notices, visa documents, and any court notices. Keep copies of everything in a safe place. Number 5, do not travel internationally if you have any pending immigration issues. Use extreme caution even with domestic travel if you have an active immigration case. Number 6. Stay connected with trusted immigration advocacy organizations in your community. Groups like the National Immigration Law Center and local legal aid offices are actively monitoring these changes and can help connect you with free or low-cost legal services. Let us quickly go over everything we covered today. 1. The Board of Immigration Appeals issued a ruling on April 24, 2026, stating that DACA status alone is no longer enough to stop deportation proceedings. This is now a nationwide legal precedent. 2. The Department of Justice has dramatically reshaped the immigration court system by firing judges, shrinking the Board of Immigration Appeals, and issuing precedent decisions that overwhelmingly go against immigrants. 3. A new rule tried to cut the immigration appeal window from 30 days down to 10 days. Courts have partially blocked it, but the legal battle is still ongoing. 4. Third country deportations are now a real and growing threat. Immigrants may be sent to countries they have no connection to. 5. Those most at risk right now are DACA holders, people in open removal cases, immigrants with minor criminal records, and those without legal representation. 6. The single most important thing you can do right now is consult an immigration attorney. Know your rights and know your deadlines. These are not small or technical changes. These are major shifts happening right now in 2026, and they are affecting real people and real families all across this country. The best protection you have is information, and that is exactly why this channel exists, to make sure you are never the last to know. If this video helped you or someone you care about, please give it a thumbs up. Share it with your family and friends who may be going through any kind of immigration process. They need to see this. Subscribe to Immigration Updates today so you never miss an update like this one. We cover everything as it happens. No rumors, no guesswork, just real information you can actually act on. Thank you for watching. Stay informed. Stay protected.